Good afternoon. Welcome to Cannabis Live. Today, Nick and I are going to discuss an overview of the state of Michigan's capitalization requirements for medical marijuana facilities. But before that, Nick's going to run us through a few quick news stories for the week.
So in this week's Cannabis News, I just wanted to provide a quick update following our Traveling with Cannabis and Hemp show from last week. Either during or on the same day as our show, the Transportation Security Administration issued some guidance on hemp-derived CBD, basically saying that products and medications containing hemp-derived CBD or that are approved by the FDA are allowed to be carried in check-on luggage and carry-on luggage at the airport. With the very important reminder that cannabis is still federally illegal. TSA is a federal agency with federal employees who are tasked with reporting potential suspected violations of the law. Basically meaning that, while their primary job is to detect threats to aviation and security, meaning they're not directly looking for illegal drugs such as cannabis, at least from federal law. If something is found, it is their duty and their job responsibility to report it to law enforcement. So there at least is some clarification with the hemp-derived CBD products, and FDA-approved ones can be traveled with on airline flights. Another agency from the federal level, the FDA, held a public hearing today regarding CBD regulations. As you know, the federal government, the FDA needs to improve CBD as generally recognized as safe. As of right now, there are only 3 ingredients that are given this designation, which does not include CBD, but the FDA is entertaining testimony and data on that particular fact point. I think the general takeaway from the hearing was that there needs to be more data, there needs to be more research on dosage and safety. So we'll definitely keep you updated on that. And then the final news is that I was going to report on a bill that was in the California legislature that allowed municipalities or required them to opt in based on if some of their voters had passed Prop 64, which is their adult use law, in action versus banning it. I recently heard that yesterday that was pulled basically from lack of legislative support. So I think in Michigan we're dealing with a similar situation where we passed with 56% of the vote. A lot of municipalities, on the other hand, are not listening to their constituents and opting in and allowing these businesses to exist. And the only way to eliminate the black market and ensure safe access and dosing is to allow more businesses in the community, otherwise there's going to be a problem. So I'd like to see some similar legislation enacted in Michigan, allowing potentially more businesses to be in existence. But other than that, I think we're going to continue to chip away at things here, both at the federal and at the state and local level, as we're seeing with some positive news. So I think that's it for the news today. I think now Travis and I can kind of jump right into our recap of capitalization and just kind of a discussion.
Yeah, maybe a little overview of how capitalization is impacting current licenses.
Based on how we've seen it, conceptualized, and how we've seen the department kind of go through capitalization requirement for applicants.
Exactly. And one other news item too, just to kind of weigh in on it, we're waiting for some news out of the state of Illinois about their legislative process to potentially legalize adult use marijuana as well. So last I heard that the news from the Senate hadn't come out yet, or the House, whichever one we're still waiting on. So when that becomes officially announced, we'll probably be discussing that next week as well. So let's talk about capitalization. Capitalization is basically a demonstration by an applicant showing you the source and total amount of operating funds, as well as funds you're going to be using to maintain your facility as you move forward with your cannabis license. These capitalization amounts we're discussing are going to be for medical marijuana facilities license holders. Those would be the medical tract licenses. And there are minimum capitalization requirements based out of the regulations that an applicant for one of these license types needs to demonstrate. We'd like to basically discuss and remind everyone what those minimum amounts are, talk about how applicants are basically able to meet or demonstrate those amounts, and then maybe some constraints on practically the way applicants are demonstrating and being tested by the marijuana regulatory agency to ensure that you're demonstrating those amounts. So when the law came together, one of the factors in the statute for our now removed licensing board to consider was your source of capitalization and the total amount of capitalization you would have. We had an advisory bulletin around November of 2017, and that advisory bulletin basically got captured into and formalized in our regulations in Rule 12. But basically what it did is outlined a minimum amount of capitalization to be demonstrated. I'm going to run through those numbers just so we all know what we're talking about, and then Nick and I are going to kind of unpack first what capitalization is and how that works. So our capitalization amounts are as follows. A Class A licensed grow needs to demonstrate a minimum capitalization amount of $150,000. A Class B grow needs to demonstrate $300,000. A Class C grow demonstrates $500,000. A processor and a provisioning center, so either one of those license types, demonstrates a $300,000 capitalization. A secure transporter or a safety compliance facility, either of those license types would demonstrate a capitalization of $200,000. Did I get those right?
Yep.
All right. I spit those numbers out so often. So what does that mean? That means if you're an applicant for one license, the type of license you're going for, let's say Class A, your company would need to demonstrate capitalization of $150,000. If you wanted to be a Class A grow and a processor, two license types, you would need $450,000, $300,000 for the processor, $150,000 for the Class A, right? So as your company seeks more than one license, you add those licenses up, and that is your total amount of capitalization. Nick, before we get into how we're demonstrating that, can we explain what the difference is between liquid and non-liquid assets when you're demonstrating capitalization?
Absolutely. And so, we kind of talked about the source of this rule and how it can be required as it pertains to applicants. Travis just gave you the kind of minimum numbers that you have to show, but also, the question becomes then, what's the source of that capitalization? And basically that, for lack of a better word, is the different types of assets that you're going to point to and show the state that this actual amount has been satisfied. The way they've broken it down is that 25% of that total amount per license doesn't include your application fees or regulatory assessment fee, but just that base number from 150K to 500K that Travis just mentioned. 25% of that per license needs to come from liquid sources, meaning easily, cash or its equivalent, or something that is easily convertible into cash if needed.
Yeah, which would be stocks, bonds.
Stocks, bonds. Basically, for purposes of this discussion, it's mainly a lot of different financial accounts and not so much real property or other kind of more substantial concrete
99% of the time you're demonstrating a liquid asset by demonstrating the balance of some sort of bank account is typically what we see. Now, most of the applicants that are currently in the queue are establishing a brand new license. They're usually seeking their first license, with very few of those license holders now quickly approaching their 1 year, so their renewal period. When you're an up and running business and you have cannabis product stock on hand, they do consider your stock a liquid asset too. So if you're a processor and you might have $40,000 worth of products sitting in your storage ready to be sold to a provisioning center, then the value of those would be considered liquid too. But since most of the licensing currently done is still for businesses seeking their first license, most of our liquid assets that we're demonstrating would either be cash or cash equivalents, aka like the balance of the bank account, right?
Right, and so as I was going over, 25% of it has to be liquid, meaning the other 75% can be liquid, but it also can be non-liquid assets. And what we're talking about there, as I kind of alluded to, is real property, either your primary residence, different rental properties, commercial properties, a lot of things tied to the land, equipment, fixtures, supplies, things that you could sell but might take a while, but they still have value. You can't show all of it, but you can show a significant portion of it with these assets in order to satisfy the capitalization requirement. So we've kind of gone over where it comes from, what the limits are, what kind of percentage you need to show, what type of asset But other than that, I mean, how do we actually go about this and put it into practice, I think is the next logical step.
Yeah, so let's talk about how we practically demonstrate capitalization. So the first thing to keep in mind is capitalization is not necessarily net worth. When I say net worth, that is the valuation of either a person or a company. The easiest way to think about it is if your business bank account has $1 million in it, and that's the only asset in the name of that company, you can easily show you're capitalized to $1 million. It's sitting there in an account, very objectively demonstratable. But a lot of times these new businesses aren't going to necessarily be funded like that. A lot of cannabis businesses aren't going to hold a bank account. So most of the projects we work on, and I'd assume a lot of our colleagues do as well, you're usually demonstrating capitalization through some sort of loan situation. There'll be a private lender that might be one of the owners of the cannabis applicant directly, or a third party providing funds to the cannabis company for purposes of capitalization. There's a lot of different ways that you can capture that, but even if, like, let's say I am a single member LLC, my LLC is going to be the cannabis applicant. Travis's LLC, let's say it's seeking a Class A license. Well, my LLC needs to demonstrate a minimum of $150,000 in capitalization. Now, personally, the owner could have money in excess of that amount in, let's say, my personal savings account or something like that. But what's important to remember is I might be the single member owner of this LLC, but I am a separate legal entity from the cannabis applicant. Just because I happen to own a business doesn't mean that business has any claim to my and my wife's private wealth. So even in that situation, you are often going to be, because you're prevented from creating, or it's not very easy to hold a bank account for your cannabis business to go fund. A lot of times what you're going to be doing is lending your own wealth or holding out some section of your own wealth for the benefit of your company. So I would either execute some sort of line of credit agreement or a promissory note from myself to my company. If you have multiple owners of your company, one of those members or more might all be doing something like that. So if Nick and I were partners on a Class A grow, Nick might be putting up $100,000, I might be putting up the other $50,000. We would both create some sort of debt instrument between our personal selves to our company, and those two documents together would demonstrate our minimum $150,000 capitalization amount. And because technically speaking, the company owes that money back to either of us, the company doesn't have a net worth of $150,000, but the company can demonstrate that it has access to capitalization of a minimum amount, namely $150,000.
Right. And I think the biggest takeaway is you need to connect the dots. So really right now what we're dealing with is three different situations, where situation one, the applicant company, you create a different corporation or an LLC, and what you'll do is open up a bank account, and let's say you put $150K in it, either from myself or from Travis or a combination of us. That's the easiest scenario. You'll submit it to Lara and they'll say, oh, okay, it's in the name of the actual applicant company, that's capitalized. They might ask who it came from and make sure to connect the dots going back. But that's the cleanest and most simple scenario to satisfy the capitalization requirement. The second one, as Travis mentioned, is sourcing it from the members or the people who are actually within the company. So if Travis and I were 50% owners, we would not be transferring money into a bank account because maybe it doesn't exist and we don't want it to be closed by each and every bank we go to. So we keep it in our own personal accounts. We don't create any taxable events by actually transferring money. But we can at least say and connect the dots and say, Lara, we're pledging a total of $150K from all of our accounts. And and then they'll add all the money up and make sure that it makes sense. But the one thing in the third scenario that I wanted to mention is that it doesn't have to be from the members of the company.
That's right.
And in that situation, you need to kind of think about how you're sourcing money, because you can run into certain securities issues if you're opening up a company and then bringing in investors. There's certain protections and certain reporting requirements that you have to comply with. So that's a little bit more of a trickier situation, but we have seen it happen. There's certain different scenarios that require a lot more attention and a lot more thought into it. But just to say that, just to kind of highlight the fact that, if Travis and I had a rich uncle and that rich uncle wanted to invest, He could also be a money lender. He could also be executing a line of credit between himself and our company that we're applying under to get that license. So it's definitely, there's a lot of flexibility, but it also depends on what your sources are, how many assets you have, if there are mortgages on those assets, what the value is. So there's a lot of consideration. There's not a one size fits all. It really depends on what kind of things you and your company and your different resources are bringing to the table.
Exactly. And it's also important to remember that if you are working with a lender, whether that person is a part of your company or not, the mere fact that you are a lender does not necessarily trigger the need to be a vetted supplemental applicant for the company. Pre-qualification and the people who become supplemental applicants is still dictated by the capacity you have in that company. Are you an owner of the company? Are you a corporate officer of the company? Are you a managerial employee? You could, in theory, be a private lender to the company and an owner of the company of less than 10%. So you are an owner and a lender, but you are still not necessarily triggering supplemental application status, aka the pre-qualification process. And in a lot of times, private lenders who want to invest in a company but aren't necessarily ready to be a fully vetted supplemental applicant will often take a smaller stake of the company, put funds up and make available, and then contemplate in the future, maybe upping their ownership percentage higher than that 10% threshold at some period to be determined in the future. And it's not until they cross that line, or it's not until they become a corporate officer, that they would necessarily need to go through the background check. So you can also use capitalization strategically to put some person or company in a position to help facilitate your company's ability to maintain its license to get up and running. And you can use that strategically to put a person that wants to be involved but doesn't necessarily want to be that involved in a position to help your company. So how do we capture basically capitalization? Like, what is the process that we would use to demonstrate our capitalization to the state of Michigan?
Mm-hmm. So as part of the application requirements, you need to show them that you satisfy a certain amount based on a certain license type. So how do you do that? The department has kind of provided guidance on, from a few ends of the spectrum, where, one of the things you need to submit is a CPA attestation letter, which basically is the check and balance between verifying whether or not that stack of money you're pointing to is actually worth that much. And so what you'll need to do is engage the services of a licensed CPA, who will then take you through a process of a formal interview where they'll discuss what assets you have available, what assets you're trying to tie up. Because again, this has to be pledged towards the applicant company. You can't say, I'm going to use my savings account, and then 6 months later that money's gone because it was supposed to have been pledged towards the applicant company. So what we do, what our CPA does, what all of our colleagues in this industry are doing, is really having a discussion that involves, legal issues, business planning questions, really kind of digging deep into what assets each of the members in the company have available to them to use. And then it's just a matter of, really picking and choosing those ones that make the most sense. And basically, once you identify those sources and total amounts from each asset, the CPA, him or herself, will go through and obtain the necessary due diligence as far as, does this checking account really have $200K in it? Mm-hmm. Is this property still worth what they're saying it's worth? There's a SEV, state equalized value, or you can get an appraisal on the piece of real property in order to do that. Then they'll do the calculations and figure out whether or not you've satisfied this amount.
If you have $100,000 in cash, you bring it to prove to the CPA you actually have it, so that they can attest to it.
Yeah, so there's all these accounting procedures that need to go into verifying if these assets are actually worth what they are. The CPA will sign off on it. The second piece of it is a statement of money lender form, which basically the LARA and the MRA have developed, which says, I'm the money lender, here's some demographic information about myself, here's the type of debt instrument, whether it's a line of credit agreement or a promissory note, here's how much that is, here's a signature authorizing the department and other law enforcement officers and anybody basically to come and ask me any more questions or get verification as to where the sources of these funds came from. And then obviously sending them that debt instrument, whether it's a line of credit agreement or a promissory note, and then you kind of let them review that and check things on their end throughout the whole application process.
So in our experience, as almost every project I know I've worked on, and I assume everyone you've worked on, typically will involve a lender in some way, shape, or form, whether that's you lending to your own company or some third party lending some sort of asset to your company. So the statement of money lender form basically captures any time the two entities are making funds available. So if in our hypothetical, Nick and I are 50-50 owners of a business, and we're each putting up money towards our capitalization, not only would we need to provide our loan agreement, whatever form that takes, but it also needs to be verified with a statement of money lender form, basically the lender confirming to Laura that yes, I did in fact agree to this. And then second, the lender needs to demonstrate evidence that those funds are available. And that can create some complications too. So whether you are your own lender or you're working with a third party lender, be advised, the state of Michigan is going to be verifying that those funds actually exist. And they do that in a couple different ways, but primarily it can be as simple as your CPA attestation letter and a balance on the account or accounts you're using to demonstrate that wealth exists. But that capitalization isn't a moment in time and then it's gone. If you're working with a third-party lender, that third-party lender is making, let's say $100,000 available, and it's available at the time you submit your application. Well, the state of Michigan, 2 or 3 months later, might be verifying that your capital is there as it continues to process your application. And if your third-party lender provided a Chase Bank account with $200,000 in it, and then 2 months later there's $10,000 in it, the state of Michigan is going to want to know how they're going to honor that debt instrument you're relying upon for capitalization when your lender can't verify those funds exist. And what happens way too often is, if you are the lender and you also own a company, a lot of people have closely held LLCs and things like that. A lot of times as they operate their lives, as they operate these businesses, I might personally take from my personal account $100,000 and put some of that into an LLC that I own. Well, that LLC is not me, so I am conceptually the money lender, and now I still have money I control. It's in this company that I own, but that company is not filled out the paperwork and verified that it is a money lender. So I can't tell you how many times this happens. That statement of money lender process now needs to be redone. You have the original lender who has a different amount of money than originally contemplated, and this new lender, technically a different business, is still 100% in the control of the person you're working with, but because that is a different legal entity, we need a new loan agreement from that entity to your business. You need a statement of money lender authorized by that business, and you need to have the state of Michigan verify that the funds held by that lender are still in existence. So if you are going to be either the lender yourself or working with a third-party lender, you need to be very careful to understand how long you need to demonstrate that capital exists. And if there are going to be changes, you need to be ready to either amend the application materials you're providing or maybe not commit that lender to a large enough amount when they need to have operating budgets and cash flowing in and out of the accounts you're using for evidence. The other thing that can tend to happen is, okay, well, you got these loan agreements and you're in your pre-qualification process and you need to show $150,000 in capitalization, but you went out and bought 50 grand of equipment. So, that's great. Now you went from liquid assets to a non-liquid asset, but be advised, as anyone who's ever bought a house can attest to you, what you buy something for and what it's worth might not be the same. So, the purchase price might not be the value of that equipment. If you get that equipment or a piece of real property appraised, you might have paid more for it than it is worth. So when you actually go spend your money, which is the whole reason the state allows you to have 75% of your capitalization met by non-liquid assets, you need to be careful to demonstrate that you can still meet your minimum capitalization requirement. And if for some reason you can't, you might need to come up with other capitalization sources, or you might need to delay your purchasing of some of these items when you're really close to the line on the total amount you need to demonstrate. So we wanted to kind of highlight some of those factors in action because when you're doing pre-qualification, which has only become more and more of the starting point for a lot of these businesses given the licensing process and its evolution in Michigan, it's very important to understand that while capitalization can be amended and adjusted, if you start engaging in the furtherance of your business without considering the capitalization amount you need to demonstrate to the state, you can put yourself in some situations where you might make it problematic to move forward.
Right, and stuff like that can slow you down. And obviously, a lot of people who are doing what we're doing are trying to forecast that and really use our experience to give you some best advice and practices for how to make sure you streamline your application as fast as possible. I know a lot of municipalities are requiring step one approval, and in certain situations, a week or two could make the difference between whether or not you can apply and are eligible for certain license types. And so, you know, when you're talking about being efficient and moving the process forward and expediting the application, it's sort of these, I don't want to say unforeseen circumstances, but definitely things within your control that you can make sure don't happen to ensure you have the most smooth sailing in the application process. And one of those things is definitely making sure you identify what capital you're using, making sure that it stays there to a certain extent in order, you know, for you not to really run into these issues going forward where you have to shuffle things around again and come up with some more liquid funds in order to, you know, reach that next step within your MRA application process. So.
Exactly. So hopefully we had a chance to kind of outline just what capitalization is, some of the factors that are involved with being able to demonstrate capitalization and anticipate the needs for presenting this aspect of the licensing process. If anyone has any questions about capitalization or any other licensing questions, we would be more than happy to go over those items with you. Feel free to comment on the Facebook feed or reach out to our offices at any time. But that's going to do it for us this week. Thank you so much for joining us, and we will be back next week with another Cannabis Live topic. So thank you so much.